So today we are going to read this topic, constitutional provisions on labor, industrial relations and social security. This is the polity part of it. It's not something that you do not know. You must have all read polity, Lakshmikant or any other source per se. But in this case, we are studying certain constitutional provisions and applying them to the labor sector or the social welfare sector, social security sector, okay? In this chapter, this is what we are going to do. It is constitutional provisions on labor, industrial relations and social security. You can expect 2 questions from this topic alone. 1 or 2. Minimum 1 is guaranteed. Okay? You might think this 1 question is either from the polity, but it will be from industrial relations or labor laws part. That particular article or particular topic that they asked from constitution, they asked it as a part of industrial relations. Okay? So 1 or 2 questions will be coming from this topic. So kindly try to recollect your polity. Labor. So if you look at labor in the constitution, it is placed in the concurrent list. Okay? I guess you already read your polity at least to certain extent. So I'll keep questioning you. If you know, well and good answer, or else I myself will tell. What article talks about lists? That is schedule. Article. Okay, 7th schedule. Which article is it? 246 it is. 246. It is Article 246 that talks about lists in the Constitution. It has List 1, List 2 and List 3. List 1 is union, state, concurrent. So, labor is placed in concurrent list. Okay? So, if a subject is placed in the concurrent list, what does it mean? Both union and state can make laws on it. So, labor is such a subject where both union and state can make laws. That is the reason we have hundreds of central laws and so many of state laws. Because everybody comes up with their own law since labor is a concurrent subject. And so union can also make laws, states can also make their own laws. Suppose if a state law is not in sync with the union law, or they are in conflict with each other, or not consistent with each other, then in a concurrent list, union law prevails over the state laws to the extent of inconsistency. Entire state law do not become invalid, but what part is it conflict or inconsistent, that part will become void. And in that case, union law will apply. You read doctrines in polity. There will be certain doctrines, right? Basic structure doctrine. You will have other doctrines also. Have you ever read a doctrine that talks about this topic? What is it? Okay, all of this more or less talk about the same. But there is in particular, specifically, there is a doctrine regarding this that says union law and state law in conflict. To the extent of inconsistency, union law prevails over the state law. Severability, this also talks about this. But in constitution, in an article, the word is clearly mentioned regarding this. That is doctrine of repugnancy. This is mentioned in Article 254 if I am not wrong. Just check this. Doctrine of repugnancy. Okay, Article 254. This says the same, but there is an exception to it. See, certain state laws, what happens is, goes to the assent of president. Not all the state laws are approved just with the assent of governor. Suppose there is a financial emergency or particular bill is forwarded to the president for his assent. So there are such state bills, right? If such a state bill that received the president consent is in conflict with a union law related to labor, then that particular state law won't become void or invalid. Then the state law will exist as it is because it received the president assent. And in that case, if a parliament wants to remove that particular provision of state law, then what it does is parliament comes up with a new law as a whole. But the state law that got the president assent cannot be void or invalid. Okay, that is an exception to this article. Understood, right? Generally, union law prevails over state law. But in the case if state law is passed with president's assent, then state law only prevails. Okay, understood? In polity, certain topics has to be on your fingertips. Preamble, fundamental rights, fundamental duties, directive principles of state policy. Once in a while, at least you have to take up your polity and read. Now, what are we going to look in this PPT or in this classes? Preamble. How can we relate the provisions of preamble to the welfare of labor or the social security? What fundamental rights are given to the labor sector? See, look at it this way. Labor are not different people. They are also the people of India. So whatever applies to the people of India as a whole applies to the labor sector also. So they are general principles or the general rights or the general duties. But certain provisions are very much specific to the labor sector. Imagine in fundamental rights you have Article 23, prohibition of forced labor, okay, or beggar. So that is specific to labor. But just imagine Article 21, right to life and with dignity. That is for people as a whole. That applies to labor sector also. They also have the right to live their life with own dignity in a proper humane conditions. So we read it in specific manner what is particular to labor sector, and we also read it in a way where it is applicable to all the people of India, and also labor is not an exception. So it is DPSPs. Because what does political rights ensure? What kind of justice do they ensure? Fundamental rights is about political justice. DPSP about, these are the statements that you find directly in your polity books. This is socio-economic justice. What is the other term for socio-economic justice? Is also social justice and economic justice together is called with a term. Distributive justice. Okay. So now we are going to read all this. And one more thing from the constitution that we cover is lists. Now in the first slide we have seen that labor is in the concurrent list. But there are certain provisions of labor. Suppose labor in the mines comes under which list? That comes under union list. Trade unions comes under which list? Okay, and dispute resolution mechanisms, under whose control it is, either state or center or concurrent list. So you have to be very specific with what topic of labor comes under what list, because that might be a probable question for your examination. So all these we will look in this PPT, and also certain judicial pronunciations or judgments. Judiciary judgments, okay, that are very important for the labor sector. Example, we have Vishaka guidelines given by Supreme Court. Okay, and we have, because of this we have POSH Act, right? Prevention of Sexual Harassment at Workplace Act 2013. So such important judgments, one or two important judgments in specific to the labor sector, we'll also cover it. I might give this topic for your self-study, but as I already told you, I want you to finish everything in the class itself so that you don't have to spend time for the subject at home. So let us look at the preamble. So preamble is like an ID card to the constitution, right? It is like the foundation. If you look at all the philosophies or the objectives that are given in the preamble, it tells you about the entire constitution as a whole. Yes, it is a preface to the constitution, or it's like an ID card to the entire constitution. Just by looking at the principles or philosophies in it, you will understand the entire constitution. What does it say? India as sovereign, socialistic, secular, democratic republic. What are the terms added in this through 42nd Amendment? Yes. I used to have a teacher named Sosin. Have you ever heard of it? I mean, she's my anthropology teacher during UPSC preparation. Socialistic, secular, integrity. So I don't have to think much. I remember her when I'm studying this. So these are the words that are added. Also remember the order in which they are present in the preamble. Sovereign, socialistic, secular, democratic, republic. What does it ensure? Justice, liberty, equality, fraternity. Okay. Now we look how all these principles are being applied to the labor sector. Just look at the justice part of it. If justice, it is social, economic and political. As we already saw, political is ensured through fundamental rights. Social and economic is ensured through DPSPs. So ensuring justice to the labor sector, so that for the purpose of industrial justice or the labor welfare or fair treatment of workers, this all can be treated as justice part of it. And next, if you look at equality, it is equality of status and opportunity. So whenever, we already discussed, conflicts might arise and all. So whenever such situation occurs, they should be treated equally. Employers, how we treat an employer, employee has to be treated equally. And we can also assume it as equal pay for equal work. Women and men has to be treated equally. Equality of status and opportunity. Opportunity, if you look at it, we have in Article 16, right? Public employment. Equal opportunities in the public employment. So all this related to labor can be treated under ensuring equality to them. Liberty. Liberty of thought, expression, belief, faith and worship. So don't you think this is the foundation for the forming of trade unions? Why are we forming trade unions? To give their voice to the unheard, to represent their problems, to give the liberty to their thought or expression. If they are feeling an expression of being dissatisfied with the provisions or the working conditions or the wages, that is why trade unions are formed. Yes. So liberty. What else? Justice, liberty, equality, fraternity. Ensuring a brotherhood among themselves and also between the employees and employers, so that they work in cooperation to achieve harmony and peace at the end of the day. You can link this with human relations approach, because this approach focuses that social relations also determine it. So if they are in a brotherhoodly relations, at the end of the day, industrial relations will be at peace and harmony. These terms are independent, no need to apply. Sovereign, secular and all. Socialist. In what approach yesterday did we talk about socialist? Marxist, exactly. What does he say? The ultimate solution for all the industrial conflicts is achieving the socialistic kind of society, where means of production are in the hands of everybody, not in hands of only single sector of the society or only in the hands of single class. And we have democratic republic. So every process has to be democratical in manner. Okay. All elections or basically ensuring industrial democracy. So this is what, how do you link preamble with your labor rights? There is next slide that says the same. Justice, social, economic, political, equality of status, opportunity, liberty, fraternity and ensuring dignity of the individual. You find that term. So you also should ensure the dignity to the labor people. Now we look at fundamental rights. Tell me what fundamental right? Whatever you remember, just keep telling. Okay. Tell me what do you think are applicable in this case, okay? Okay. 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 More of a religious provisions, right? So you pretty much, no, this is more, I mean, these articles are more than enough. So if you look at Article 14, equality before law, everybody has to be treated equally before law, even if it is the labor people, the employees, they also come under the broader perspective of people of India. So Article 15, prohibition of discrimination on the grounds of religion, caste, sex, even at the workplace, no discrimination has to be noticed regarding these factors. Article 16 is equality of opportunity in public employment. So it is in public employment, right? Why are we talking about this now? Okay, it is also one type of employment, but generally we are trying to protect. Yes, S-Day or day before S-Day, while reading the role of government as a mediator or to ensure adjudication, all these we have read. There is also one point that government's role is also an employer itself in certain cases. So government as an employer should ensure that equality of opportunity is maintained in their public employment. And Article 19, as you already said, but if you go specifically, it is Article 19, Clause 1, Clause C. Okay? That talks about right to form associations or unions, which is the base for forming trade unions. Next, Article 21, right to life and personal liberty. If you see, the Supreme Court or the judiciary has continuously kept broadening the scope of this article. If you find, if you look at the scope of this article, it's like it kept on increasing a lot because the interpretation is in such a broader manner. Now, these are certain provisions. See, these three are core to the labor sector. Rest of them as a whole, where labor sector is also included. Now, Article 23 is prohibition of trafficking in human beings and forced labor. What is meant by trafficking? Okay. It's basically, in simple words, it's buying and selling of human like a commodity. You're treating the humans like a commodity and buying and selling them and exploiting them. That is trafficking. So, Article 23 speaks about prohibition of trafficking in human beings and forced labor. Article 24, prohibition of employment of children below 14 years. This is important. In hazardous industries. If you properly look at the Article 24, it says no child below the age of 14 should be employed in factories or mines or in hazardous employment. Okay. This is just simply we have written here, but further classes we'll read about this Child Labour Abolition Act. In that there will be clear definition of child and an adolescent. Generally, we consider up to 18 years also it is like children only, right? So, child between up to 14 years is child, is defined as child. 14 to 18 is defined as adolescent. So, in Factories Act or Child Labour Abolition Act, there will be specific provisions in what kind of industries can they work. If it is a family-owned industry, simply the child might be helping his father or mother, no? You can't say this can't be done, this is child labor. So there are certain provisions of it, specificities of it, in what kind of industries they can actually indulge in, or in what kind they cannot, or 14 to 18 years children or adolescents where they can engage in, where they cannot. They tell in detail in those laws. We'll read about that. So let us go to the Article 23. So these two articles at the end, we'll read it in detail, a little more detail. Article 23. So it is prohibition of trafficking in human beings and forced labor, right? So what is forced labor? Okay. 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 Any other thing than that? Okay. Pretty much forced labor is what everybody assumes is of physical coercion or physical force. Now, to avoid this forced labor, the government has come up with certain acts to avoid this. Bonded Labour Abolition Act. We'll read all the acts in detail, okay? Bonded Labour Abolition Act, Immoral Trafficking Prevention Act, Child Labour Prohibition and Regulation Act, Minimum Wages Act. What is this relevance here? We're talking about labor. Why are we talking about minimum wages? Why do we put it in that sector? That column. Any guess? Okay, that is a common phenomenon. Labor should have bare minimum wages to ensure their livelihood is not threatened. But why do we include it here in forced labor? Why did we include it as a definition of forced labor? You understood my question? See, my question is very specific. Minimum wage ensure cheyali. Minimum wage ensure చెయ్యకపోవడాన్ని మనం ఫోర్స్ లేబర్లో ఎందుకు ఇంక్లూడ్ చేసాం? ఈ కాన్సెప్ట్ ఆఫ్ ఫోర్స్ లేబర్లో ఎందుకు ఇంక్లూడ్ చేసాం? సో దట్ ఈస్ హౌ యూ హ్యావ్ టు రీడ్. వెన్ యూ రీడ్, జస్ట్ డోంట్ బ్లైండ్లీ రీడ్. థింక్ అండ్ రీడ్. So there is a judgment called PUDR versus Union of India, People's Union for Democratic Rights versus Union of India. In this judgment, what the Supreme Court says is, even if minimum wages are not paid, that is also a forced labor. It broadened the definition of forced labor in this particular judgment. Yes, concept of surplus labor. They're exploiting the labor without paying the wages that they are actually entitled to. So that is why we included this Minimum Wages Act here. Okay, because even if you are paying less than the minimum wages, that is also forced labor. And anyone can file a petition, writ petition under Article 32 to Supreme Court or Article 226 to High Court that their Article 23 is violated based on just their minimum wages are not paid. It is not any physical force or coercion being applied here. They're just not being paid the minimum wages. Even then, a petition can be filed against them. Understood? This act we'll read in little more detail. But this made Article 23 a very strong tool to fight against this labor. I mean, forced labor. In short, Article 23 protects human dignity by banning trafficking, beggar and forced labor while allowing the state to demand compulsory service for public purposes without discrimination. Okay. Now Article 24. No child below the age of 14 years shall be employed to work in any factory, mine or engaged in any other hazardous employment. So it is not like in all kinds of employment. Even Constitution is clear with the terms. Any mine or factory or engaged in any hazardous employment. While reading Factories Act, you read the definition of what factory is. So what all comes under the definition of factory? In that particular definition, the child should not work, or in any mine or anything that is described as hazardous work or hazardous employment. It is specific. If a statement comes up in an exam saying in all kinds of employment, yes, child labor is prohibited. Do not think it that way. If it is too specific, think it specifical. Now, what are the related laws that stemmed out of Article 24? Child Labor Prohibition and Regulation Act, 1986. It was amended in 2016 and now it is called Child and Adolescent Labor. Prohibition and regulation. They are not only prohibiting it, but also regulating it. If the name is changed or a particular word is added to an act or law, it holds a very prominent significance. Do not just read it like that. Now, right of children to free and compulsory education. While we are preventing one thing, we should provide the education also to the children at the same point. So, Right to Free and Compulsory Education Act also we ensured, RTE 2009. Judicial support. The Supreme Court has repeatedly emphasized that, suppose if they ask, child labor violates what articles of the Constitution? And in options, you might have Article 24 in the first option A, directly you ticket and come. But maybe in B, C, there are Article 21 and Article 23, and D option you have all the above. But Sida, you saw Article 24, you ticked it and came. No. It is child labor violates the spirit of Article 21 also, right? Right to life with dignity. 23, because that is also forced labor. And Article 24. So only after looking at all the options in an examination, you have to answer a question. So I hope fundamental rights are clear. 14, 15, 19, 23, 24. 19, 1C. Be specific in that also. Okay? Now let us move to DPSPs. These are important. Directive principles of state policy. So whatever is mentioned here, it is a way to direct the state government to formulate certain laws or frame certain rules for the welfare of people, specifically social and economic justice, that is distributive justice. So Article 38, Article 39, 41, 42, 43, 43A, 38, 39, 41, 42, 43, so far. Okay, Article 47 also. This DPSPs is very important. You have to, what all you have to remember, I am saying you first of all, articles, okay, and amendments. There are many amendments, right? 42nd, 44th, 86th, 97th, all these 4 amendments. What through these amendments, what all articles are added or what all has been changed in DPSPs. That is also you should be very perfect with. So if we look at it, Article 38, it states state to promote social, economic and political justice. I mean, these are just shortcuts of the broader statement. You just go and read what the article exactly is written in the Constitution. So Article 38, is Article 38 amended anytime? Amended or not? You don't know or not amended? Don't know. Yes, it is amended. 44th amendment is there, right? It added certain words to it. Okay. Like to minimize the inequalities in income, facility, status and opportunity. There are some inequalities that are mentioned. What it is also you should be clear with. So 44th amendment 1978 added that statement to minimize the inequalities in income, status, facilities and opportunities. That statement is added to Article 38. So Article 38 is amended. You might not find 38 capital A here, but that is amended. Okay. So 39. Under 39 also we have many sub-articles, right? 39 small a to small f. All of them are also very important. Each and I mean, what is 39 small a, 39 small b, c, d, e, f? All of them you have to read. Securing right to livelihood, equal pay for equal work and preventing exploitation of labor. We'll see 39 in detail. So 41, right to work, right to education, right to public assistance in case of unemployment, old age, sickness or disablement. If you see this article, right to work. To ensure right to work, central government or state government has come up with many schemes. Imagine MG Narega. That is to ensure right to work is provided to people. Right to education. We have, see the act itself, right? RTE 2009. And right to public assistance. In what cases? In case of unemployment. There are schemes regarding right to assistance in case of unemployment. See, during COVID, to ensure employment is continued and employer do not waive off or lay off the employee, government has come up with Atmanirbhar Bharat Rozgar Yojana, ABRY. Now there is another scheme, Vikasit Bharat Rozgar Yojana, which is also known as ELI scheme, Employment Linked Incentive. If employer generates new employment, then employer will be given certain incentives. Employee will also be provided certain incentives. So all the schemes government is coming up to ensure that the unemployment rate reduces or there are no cases of unemployment. Right to public assistance in case of old age. All the pension schemes, Atal Pension Yojana or under EPFO also we discussed 3 schemes were there. EPS, EPF and DDLI. So EPS scheme is also regarding old age pension. So EPS scheme and other schemes like Pradhan Mantri Vaya Vandana Yojana. All of these are to ensure assistance to old age people. And sickness. Even for sickness also we have schemes like Ayushman Bharat, which is also known as Pradhan Mantri Jan Arogya Yojana, to ensure assistance to sick people. And under ESI, many medical benefits are given. That is also an assistance, form of assistance to sick people. Or disablement, we have Act, Rights to People with Disabilities Act, okay, to ensure the assistance to disabled people. So this article, you just take it as a homework or I'll ask you some point in time. Right to work, what are the schemes which are available? Maybe you don't have to know all the provisions of it, at least know the basic provision, the core provision of acts. Right to work, right to education and right to public assistance in all these 4 cases. All these laws associated with, I mean certain schemes associated with this article, right? Make notes of it. Okay. Article 42. Just and humane conditions of work and maternity relief. To ensure this, we have Maternity Benefit Act. We have Factories Act to ensure safe working place. So for every provision in DPSP, state or the government has tried to come up with one or more laws or acts or schemes. Now let us look at Article 39 in little more detail. All the subsections. Right to adequate means of livelihood for all the citizens. How do you ensure that? By paying more than minimum wages or at least minimum wages. Equal pay for equal work. from both men and women. This is, yes, we have Equal Remuneration Act 1976, I guess. So to ensure this provision, we have that act. Ownership, very good. Which approach? Which approach? Marx. What does he say? Haves and have-nots. It shouldn't be that way. Wealth should not be concentrated in the hands of only few. The same thing is mentioned in the C and D. Ownership and control of material resources to be distributed for the common good. And if you look at this term, don't you think of one approach that we read yesterday? Distributed for the common good. Yes, trusteeship. Don't you think? The rich are just the trustees or the caretakers of the wealth. At the end of the day, they should distribute everything for the common good of the society or for the labor welfare. Prevention of concentration of wealth. This, if you talk in specific, we can relate it to Marxist approach. And next one, E, health and strength of workers. Men, women and children shouldn't be abused and have to be taken care of. F, children are given opportunities to develop in a healthy manner, free from any exploitation or discrimination. Of all this, what is added through 42nd Amendment? One provision is added through 42nd Amendment in this. Where is right to education here? I guess 39D is equal pay for equal work, right? అంటే అలా అక్కర్లేదు కానీ అట్లీస్ట్ 39లో ఏమేమి ఉన్నాయని తెలుసుకోవాలి. Adequate means of livelihood 39A. This is B and C. D is equal pay for equal work. But this will be asked. This is 39D. ऊपर नीचे हो गया. This is B, this is C. Okay. Just correct it. Okay. Sorry. So 39F, the provision regarding children, is added through 42nd Amendment 1976. And 39 capital A, what is it? Free legal aid to the poor. This is also added to 42nd Amendment. So far, I told what are added through 44th Amendment. In Article 38 is amended. 42nd, 39 capital A, 39 small f, which is children are given opportunity to develop in a healthy manner. Okay. I'm revising it as a part of polity also, not only just as part of this subject. So 42nd, if you look at DPSPs, 39 capital A, 39 small f, 43 capital A, 48 capital A. Okay. If you look at 44th Amendment, it amended Article 38. 86th Amendment 2002, Article 45. The content of Article 45 in DPSPs is shifted to fundamental rights. Okay. And 97th Amendment 2011 that talks about promotion or promotion of cooperative societies. So if you just keep this table at one point and if you see it 3-4 times, you will remember it. Okay. Always make a short notes or boxes to remember. Okay. Or else you will forget easily. Now there are other articles. 43, ensuring the living wage, decent standard of living and social or cultural opportunities for workers. 43 capital A is very important. To ensure workers' participation in management of industries. So to ensure industrial democracy. While decision making or any management decisions are being taken off, workers should also be engaged in that particular decision and play a role in it so that participation of workers in management. You will find the provisions of it in almost all the acts. 1 or 2 provisions will be there. In Industrial Relations Code, we have Industrial Dispute Act and Standing Orders and Trade Union Act, right? So how can trade union represent themselves? In that you will look at these, maybe not specifically to this point, but you find that point as a part of many laws or acts, okay? 47, duty of the state to improve public health and nutrition. How do we ensure public health and nutrition? We already saw in 41, right? There are certain laws related to ECI or health insurance that ensures this. So DPSPs are very important. If a question has to come, most probably it is from DPSPs regarding to this topic. Next, fundamental duties. There might also come a question like, what parts of the Constitution deal with labor? Part 3, fundamental rights. Part 4, Part 4A, all of the above. All of the above. Fundamental duties. So, what approach? Yesterday we read one approach that says, while asking or demanding for rights, parallelly ensure your duties are fulfilled. Good. So that is how, when you are reading certain thing here, just go back and think whether did you read a similar thing in before classes or heard of it in before. When you link the subject and read, it would be much easier to remember things. So you don't have to remember these. Just 51 capital A. All the articles are present in that only, right? In fundamental duties. Promote harmony and spirit of common brotherhood. Renounce the practices that are derogatory to the dignity of women. So it basically talks about gender equality at workplace, maternity relief, or promoting the harmony and spirit of common brotherhood. So to avoid conflicts, to ensure cooperation and harmony. Next, protect and improve the natural environment and also have compassion for living creatures. So there is a code, right, in new social security codes, Occupational Safety, Health and Working Conditions Code, 2020 code. So that is related to the occupational safety, health, and how do you maintain the environment. All these are being talked in that particular act. Even Factories Act talks about it. Strive towards excellence in all spheres of individual and collective activity. So it is talking about how a worker has to perform in its individual ability and also as a group, as a trade union, how collectively they have to work for the greater good. And see, this is added by 86th Amendment. Provide opportunities for education to the children between 6 to 14 years. We can link this to abolition of child labor or Right to Education Act 2009. Okay. As I already told you, this also you take it as homework. I did not mention all the pointers in each list. We have, what is the article that we talked about? Lists are present in 246. 246, we have list 1, list 2 and list 3, right? So just search in Google or in book anywhere, find what topics of labor come under which list. Union list, state list, concurrent list. You make a table like this in your notes and study it, okay? So that if any question comes like trade unions are under which list, or it might come like who can make a law regarding trade unions. Sometimes it might not be a direct question. Who can make a law? In the sense, he is asking what list that has come under. So look at concurrent list. We have topics like trade unions, disputes, social security, insurance, welfare, maternity benefits. So in that particular subjects of labor, both state and union can make laws. Union list, labor who are in mines, oil fields, trade, interstate migration. Obviously, one state cannot come up with a law for interstate migrants. So interstate migration is a topic under union list, or who the people who are working in mines or oil fields. A state cannot make a law out of it even if the oil field or mine is present in that state. Only union can make a law on it. State list, labor disputes within the state. The mines might belong to the state government, but the law regarding it will be made by central government. Maybe regulation will be done by the state governments, but it is the union that can make laws on it. Okay. Labor dispute within the state, regulation of fairs, shops or establishments. Fairs, matlab exhibitions kind of thing, no? Small shops or small establishments, all this can be controlled by. Within the state, in the sense, interstate shouldn't be there. In the state disputes, whatever are corely of the state. Minor, right? That is, minor minerals. This is mines. అలా కాదు. ఇప్పుడు మినరల్ వేరు, మైన్ వేరు. కోల్ మైన్స్ అంటాం, శాండ్ ఏమంటాం, మైన్ అంటామా, మినరల్ అని అంటాం. I'll get back to you, I'll get clarity and tell you regarding that. But You don't have to go into so deep. Act law ఇచ్చేసి ఇది స్టేట్ గవర్నమెంట్ అంత డీప్ అడగరు. మెయిన్ సబ్జెక్ట్స్ అంటే ఈ లిస్ట్లో నువ్వు ఫిగర్ అవుట్ చేసుకుంటే చాలా సబ్జెక్ట్స్ వస్తాయి, అన్నీ వద్దు. అంటే ఇట్స్ రిడెండెంట్ టాస్క్ కదా. ఇంపార్టెంట్ ఏది అని నీకు అర్థమవుతాయి. సపోజ్ ట్రేడ్ యూనియన్స్ కానీ, డిస్ప్యూట్ మెకానిజమ్స్ కానీ, ఇంటర్స్టేట్ మైగ్రెంట్స్, మైన్స్, ఆయిల్ ఫీల్డ్స్, ఇవన్నీ ఎక్కడ టర్మ్ అయి ఉన్నాయి అని ఒక 5 నీకు 5 ఏది ఇంపార్టెంట్ అనిపిస్తుందో అవి లిస్ట్ చేసుకో. అంటే ఎగ్జామ్కి పాసిబిలిటీ ఆర్ ప్రాబబిలిటీగా క్వశ్చన్స్ అడిగే ఛాన్స్ ఉంది అనుకున్నావు మాత్రం. ఇంకా ఉంటాయి. సో ఇంతవరకు సోఫా వి రెడ్ లేబర్ in the constitution. Now social security, what is core principles or articles regarding social security? 41, 42, 43. 41 is right to work, education and public assistance in the case of unemployment, old age, sick and disabled. Each and every term you should remember in an article. 42 is just and humane conditions, providing maternity relief. 43 is decent standard of living. Okay. These particular articles provide the base for foundation or formation of ESI Act or EPF Act, Maternity Benefit Act, Payment of Gratuity Act or Social Security Code of 2020. Okay. There are certain landmark cases that are associated with the labor constitutional provisions. You don't have to read all of them. These 2 are important, but you can just go through it to understand how the Supreme Court or how a judiciary is interpreting the labor rights. To understand that, you might go through all of them. I already discussed this People's Union for Democratic Rights versus Union of India case. We'll deal it in detail. And equal pay for equal work. See, that case is called Ranveer Singh versus Union of India. Supreme Court held equal pay for equal work is a constitutional act. If you want to read, you can just read in detail, or simply what are the cases, what is it related to. Like a match the following, you can just by heart them. Labor codes, what are the recent developments? Labor codes. E-Shram portal, there is also another portal called Shram Suvidha portal. All of this we have to read. So at the end, Indian Constitution ensures labor welfare and industrial peace. See, this FRs, DPSPs, FDs, together we called Trinity of the Constitution, right? They ensure the labor welfare. Judiciary expanded the rights. Any doubts in this? This is a simple topic, but you'll gain marks if you are perfect with it. 1 or 2 questions. I told you, right? There is a case called People's Union for Democratic Rights versus Union of India case. PUDR versus Union of India. In 1982, Asian Games were, the venue for the Asian Games is in India, New Delhi. So what happened? There are many labor people or contract laborers or many labor were engaged for this conducting of Asian Games, either for construction of stadiums or for construction of other sports infrastructure, the roads, flyovers. There are like so many of workers engaged in this activity. Then an NGO called, this is an NGO, PUDR, that studied the labor in that particular, who are assigned to this particular task. And this PUDR noticed that there are a lot of violation of labor rights in this case. Like the labor were living in such a inhumane conditions. Okay, they were not provided basic sanitary restrooms, or they are not provided safety drinking water, or they are not having proper places to live, or even they're not paid, the minimum wages are also not being paid. All these are noticed by PUDR, and then it filed a petition in the Supreme Court under Article 32. Okay. Then the Supreme Court has given certain judgment regarding this. That case is called PUDR versus Union of India. Since this case is related to the Asian Games, this is also called Asiad Games case. This is of year 1982. And in this Asian Games, the labor who are involved also include the contract laborers. So they are not all the laborers are not mostly directly appointed by government. Government will appoint certain contractors, right? Through which the contract employees will be appointed. So now there are many questions in front of the judiciary or the Supreme Court that now PUDR filed a case saying that this is a violation of Article 23. That is why they filed a writ petition under Article 32. Now, Supreme Court has certain questions in front of it, whether paying less than minimum wage, can this be a violation of fundamental right under Article 23? And can anyone file petition under it? Is one question Supreme Court is having in front of it. And it is a responsibility of contractors to ensure the welfare or the measures to the contract laborers. But in this case, government is the principal employer or the main employer of the contractor itself, right? So who is responsible in this case? Is it the contractors or is it the government? Who is the principal employer? That is also one question. వచ్చింది కానీ ప్రాబ్లం ఏంటంటే ఒక యాక్ట్ని వైలేట్ చేస్తే సర్టెన్ ప్రొవిజన్స్ ఉంటాయి దానికి పీనలైజ్ చేయడానికి, కానీ దాన్ని పీనలైజ్ చేయడానికి మనం ఆర్టికల్ 23 ఫండమెంటల్ రైట్ వైలేషన్ కింద దాన్ని మనం చూడొచ్చా చూడకూడదా? దట్ ఈస్ ద క్వశ్చన్ నౌ. సో ఆల్ దీస్ క్వశ్చన్స్ వర్ ఇన్ ఫ్రంట్ ఆఫ్ Supreme Court. Now we'll see what judgment is given by the Supreme Court. Okay. So this is related to Article 23, protection against trafficking and forced labor. Background that we already discussed. It is also known as Asiad Games. This was a case of 1982 in New Delhi. No payment of minimum wages. They are being exploited by contractors. Forced labor practices are also being observed. And this particular case, Supreme Court also expanded the scope of what comes under the definition of forced labor. Okay, that also we'll see. PUDR filed a writ petition under Article 32 to the Supreme Court. Now the questions before or issues before the court are, does non-payment of minimum wages amount to forced labor under Article 23 is one question. Now workers were employed through contractors, right? So what rights can we guarantee to them? What is the scope of Article 32? So this is the public interest litigation, right? PIL. What is the scope of it? That also Supreme Court discussed in this case. Remember this person name? His Justice P.N. Bhagavati, who gave the judgment of this case. In this case, what they declared is non-payment of minimum wages is forced labor. And hence, if anyone is not paid the bare minimum wages, they can come to the Supreme Court and claim for their fundamental right. They can file a petition to the Supreme Court or High Courts under Article 226. As we already said, it expanded the definition of forced labor. Forced labor includes the economic compulsion. This is such a progressive step or progressive thought that Supreme Court has come up with. So far, what we think forced labor is if someone is forced to work by coercion, I mean physical force, but it said economic compulsion. If poverty or lack of financial resources or lack of money is pushing them to work, even for a minimum wage, they do not have any money. So they are doing a work of supposed to do a work of 20,000, worth of 20,000. But in that case, they are not having money. So even if you give 5,000 for them, they are ready to work. Even if you are paying them minimum wage, they don't care because all they need is at least some money. So economic compulsions should not be a cause of forced labor. So forced labor includes the definition of economic compulsions also. Who should ensure that these economic compulsions are not there? Government has to ensure, right? It has to come up with certain measures to eliminate the poverty. That is how economic compulsions can be eliminated. Government cannot escape liability as a principal employer. Government just can't say, I don't know who the labor are. I employed the labor through a contractor. No, it doesn't work that way. Government as a principal employer should have the responsibility whether the contractor is ensuring welfare to the labor or whether he's paying the minimum wages. Okay, now we have many government establishments, suppose Airport Authority of India or many other establishments, GSI, you have GSI in NAD, Geological Survey of India. So even our department, EPFO, everybody have outsourcing employees, okay. They're not government employees, just for other works, we employ them. In that case, we are the employers, right? We should also ensure that all the welfare, we pay them, we ourselves should pay them PF because they are also employees. So government cannot escape the liability. So how do we employ them is we don't directly employ. Suppose we have data entry operators in our office, DUs, for any data related work, data related entry or any simple works. So we don't appoint them directly. We have a contractor, we bid for them. Whoever bids the lowest, we'll give the contract to him. But since the contractor has employed, we cannot say we don't take care of it. The contractor has to regularly submit the data or report, how much wage he is paying, whether he is debiting the contributions of the member to the PF or EDLI benefits they are ensuring. Because EPFO through contractor is employing, because contractor is there, EPFO cannot just say, no, contractor will look after it, I don't care about it. No, it should also take care about it. So that is what Supreme Court meant here. Government cannot escape the liability. As a principal employer, it should ensure, right, contractor is doing everything right or wrong. It should not completely leave it to the contractor. It should ensure Article 21. They filed that this is against Article 23, but Supreme Court also said this is also against Article 21. Right to life includes right to live with dignity, right? Human conditions are not provided to them. It's a violation of Article 21 as well. Strengthened and broadened the concept of PIL. Scope of force, as we already saw, it's not just physical force. It is also economic compulsion, economic force. If poverty, hunger or destitution is forcing you to work for a minimum wage, that is also, in that case also you can file a writ petition or a PIL. Legal force, compulsion by law or penalty. Okay, if a law is forcing you to work, even in that case, that is against the forced labor provisions. Court ruling, working below minimum wage. So final, this is the main. Compulsion by law or penalty. In negative sense. It is a directive to the government. No law should, even government make some laws or any penalties. Even in that case, it should ensure that because of that particular provision, no one is forced to work. Judicial remedies and enforcement. Any person. So in this case, what you should remember is what is the case name, what is it also called, who is the judge who is involved in this, what is the definition of forced labor given in this judgment, what is the scope that has been expanded. All this can come in single question. Judicial remedies and enforcement. Any person subjected to forced labor can approach courts under Article 32 and 226. Then courts will direct the payment of minimum wages. Protection extended to vulnerable individuals. Judiciary has the responsibility to safeguard the rights. What is the state's duty here? To ensure no violation of Article 23. Active prevention of forced labor. Not only after the forced labor has come into place, even before, government should come up with certain measures to prevent the forced labor in the first place. Periodic inspections required. If you employ a contractor and just leave it like that, no, that is not how it works. Inspections have to be conducted to ensure that. Cannot rely only on complaints for action. Supreme Court just says, we are getting to know all of this just because of some NGO has filed an PIL. No, we cannot just rely on that. Regular inspections have to be taken, reports have to be published to know about the provision of forced labor or how is it existing in the society these days. Read the key principles. These are the 4 key points that came up in the judgment. Forced labor definition expanded, same points that we already discussed. These are also same points. Just go through them. So it improved the enforcement of that. Once again, the issue has come into limelight, right? So everybody will be aware. No, now to dena padega minimum wages. Gone through this slide. So trafficking in human beings, even if it is done by the state players or the private players. Forced labor, physical, legal or economic compulsions. Economic circumstances, below minimum wages is a forced labor. State responsibility, do not wait for the complaints to come. Proactively take preventive measures in order to avoid this forced labor in the first place. Judicial remedy is to file petitions under Article 32 and 226. Any doubts in this class? This is simple, right? So let us take on another topic. Let us look at this topic. Theories of employee welfare. This topic, I came to know that this topic exists because I have seen 1 or 2 questions from this topic in some previous year question. So, theory, you know what theory is? Employee welfare. So every industry or every employer or every management or owner, everybody does something or the other for the welfare of an employee, for sure. But their intention for doing it might not be the same. Some just might do it for publicity. Some might do it just to gain the respect in the society. Some might do the welfare activities seriously out of their concern because they're so kind, they're so generous. They seriously want to do something good to the society or the labor welfare. Okay. Some might do the welfare just because, see, certain religious people will be there. They might not be truly kind or truly generous at their heart, but they think that, no, if I do service to the people or labor, God will pay me back. Okay. So the concept of employee welfare is not same for everybody. Everybody might do it, but with different intentions. That is what we talk about in this theories. Okay. What theory? In what theory? How are they doing the employee welfare? With what intentions they are doing employee welfare? This is what we're going to see. Employee welfare, what does it mean? Providing them facilities or services or wages at the end to improve their quality of life or to provide them better standards of living. It is provided, employee welfare is provided by who all people? It might be an employer, it might be state, it might be trade unions. Among themselves, they'll help each other, right? Trade unions. So, welfare theories explain why such activities are undertaken. Okay? With what intention they are doing this employee welfare. Broad classification is policing theory, religious or moral theory, humanitarian theory, philanthropic theory, economic theory. We'll finish it off. This is very simple, even very simple to answer once you understand. Policing theory. This is just because of legal compulsion. If someone does welfare activities because of legal compulsions, Act has asked them to do. If the Act do not ask them to do, they will not do it. Suppose factories that ask them to provide safe drinking water, or every establishment should have a canteen. Every establishment should have a crèche for lactating and pregnant women or for the children of them. Only if the Act asks them to do, they are doing, or else they'll be punished or penalized. Not with the core intention. So, not with genuine interests. This is what policing theory is. Core idea is welfare due to legal compulsions. Example, Factories Act, ESI Act. So, just a simple question, which theory considers welfare as law-driven? Policing theory. Religious or moral theory. As I told you previously, one example, they do it out of the religious mindset of them. Certain people are so religious, they believe in God. So, with their spirituality, they think that if I do good to they derive the spiritual satisfaction by doing the welfare activities. It is for their spiritual satisfaction. You might call them a little to some extent genuine interest, but at the end, it is for their satisfaction of spirituality. Core idea is guided by faith, ethics, duty. If you look at Hinduism, we have certain concept called dharma, punya, karma. There are people who believe in the philosophies of Hinduism, like karma. If I do good, I'll get back the good. Okay. In Islam also there are certain philosophies like sadaka. I don't know exactly how it is pronounced, but jakat or sadaka, if you do some help or some good things to people with pure intentions or sincerity, that will reach to Allah. That is what they believe. So that's the reason certain people of Islam religion do welfare activities. Christianity, we have charity. They believe service to mankind is service to God, or all the people are children of God. This is what they believe. With that intention, they do certain welfare activities. Gandhi's trusteeship is also based here to some extent because he believes in moral consciousness, right? When we read Gandhi's theory, we read that it is the most moral theory, moral kind of theory. So we can relate that concept also, like not 100%, but to the extent that it also believes on ethics and duty part, but mainly faith. Because of faith, they are doing it. So if a question comes, trusteeship concept relates to which theory? You might answer it this way. Philanthropic theory. This is some theory where employee welfare is done out of pure interest of helping people. because they are so generous, they are so kind. Example, Tatas. They set up hospitals, they give scholarships to the employees who are working in there. To the children of the employees who are working. They set up schools. They do so many activities. So it is employees' generosity. They feel that it is their responsibility to give back to the society. They are the people who are having it. So they believe it is their responsibility to give to those who are not having it. Okay? It is with a pure intention. They do philanthropic activities. So which theory links welfare to the generosity or kindness or affection towards the workers? Then this is this theory. This theories only have 1 point. It's not like last day approaches which are having many points and do not end. A theory do not end easily. Humanitarian theory. This is based on sympathy, kindness to reduce the worker suffering. So you might ask me, what is the difference between philanthropic and humanitarian? Philanthropic is a little broader one. In philanthropic theory, what they do is set up schools or set up hospitals, set up coaching institutions. They do big things. Humanitarian theory, you don't have to do so much big. Not broader things, big things. No, simple things like give them the good drinking water, safety drinking water, hygienic restrooms. Okay, give them places to rest. Give them holidays on weekends. The bare minimum things that you provide for a human. Treat them as humans first, not like objects or, just like factors of production. That is the difference between humanitarian theory and philanthropic theory. Philanthropic theory, big philanthropic activities are being undertaken. In humanitarian theory also they might set up a hospital or school, but beyond that, before that, provide the bare minimum essentials to the employees' welfare. Humanitarian is a part of philanthropic, but generally in philanthropic, they'll do big things. Humanitarian theory speaks about at least do things or welfare to humans by treating them like humans. Like labor should be treated as humans and all the welfare has to be taken place. Trusteeship theory we already did. But if you look at it in the point of welfare, what does Gandhi say? You have to do the welfare because you are the trustee. You are the caretaker. That is why you have to do the welfare. That is what Gandhi says. So this theory might be, this pointer comes under this theory of welfare. Placating theory. What does placating mean? Pacifying someone, making them calm down. So this is purely not of interest, not of genuine interest. It's like some strike is taking place. Police are yet to come or government is yet to come. Then the industry people or the management will say, calm down, we are hiking your wage to 5,000 rupees more. So at the point they want calm, industrial unrest shouldn't be there, peace and harmony has to be maintained. That's the reason they do welfare activities. So that is not like a primary action that they take place. Only if something happens to react, that is more like a reaction to unrest. Okay, just to stop a protest or just to stop some strike or just to stop some industrial unrest. So placating is pacifying someone, making someone calm down or cool down. So bonus or housing colonies just after strikes, they give them so that they'll get temporary satisfaction and they'll stop the strike. Welfare as a strategy to maintain peace. This is a welfare as a strategy to maintain the peace. Public relations theory. This is basically the PR stunt. They do the activities, but while doing, they call all the YouTubers, they'll call all the media to publicize it, to publish in all the televisions. Why? They want that fame. They want that respect in the society, or they want that good name among the employees or the labor people. That is why they do it. More of to ensure the public relations. Welfare to build goodwill and reputation. They want the respect or goodwill among the people. There might be other factors. If goodwill is established in the society, their products might sell off well also, right? So this is the core idea of PR theory. Example, sponsoring schools, hospitals, sports in colonies. They sponsor it. At the same time, they'll publicize it. Welfare as a goodwill tool to achieve goodwill in the society. That is PR theory. Functional theory. In this theory, what happens is, if we do some welfare to the labor will be happy. They will do the production activity very well with so much of efficiency. At the end of the day, that benefits my industry. So it is selfish intent, but they're doing welfare so that it boosts their functionality. Employees will work with more efficiency or more productivity. That is what functional or efficiency theory says. Principle is happy workers equal to productive workers. Example, they do many activities, training, health, canteens, all of this. Possible question, welfare linked with productivity. What is the welfare? What is the theory that is linked with this? Functional theory. Social theory. In this, they'll think like industry or a labor is a sub part of society. Since industry is also part of society, it is a duty of the owners to do something to the workers as a part of societal perspective. Suppose a corporate social responsibility. If it is a factory or an industry that is resulting in certain pollution, environmental pollution, so it is affecting the society as a whole. So in order to reduce the effect of that pollution, they'll be given certain amount of plantations or trees to plant. So they are giving it back to the society. Corporate social responsibility is a classic example of social theory. Hope you're clear with all the approaches. We did it pretty fast, but that is what it's required. We are doing as much as required. Policing is because of compulsion of law. Then religious, because of their faith, they do it. Because service to mankind is service to God. Philanthropic, out of generosity or kindness they do. Humanitarian approach, sympathy. Trusteeship, as a employer is just a trustee and caretaker, so he has to do. Placating, to pacify after the strikes. Public relations, to achieve the goodwill. Functional, if they're happy, they'll produce more. That is why we have to do welfare activities. Social, as a part of social duty. It is a social duty. Simple question. CSR is a policing. అంటే చెప్పు లేదంటే yes, it might be a part of it, but this is one example of CSR. I mean, one example is CSR. అర్థమైందా? సిఎస్ఆర్ అనేది ఒక ఎగ్జాంపుల్ మాత్రమే. సోషల్ డ్యూటీ ఇది మీది అని చెప్పడం. డ్యూటీ అంటే వాళ్ళు చేయాలి, కంపల్సరీ చేయాలి. ఇట్ ఈస్ ఆల్సో రిజల్టింగ్ ఫ్రమ్ కంపల్షన్. యాజ్ అ సోషల్ డ్యూటీ యూ హ్యావ్ టు డూ దిస్. Okay, but that is more of a legal duty. You understand the difference? That is a legal duty. This is a social duty. Both are out of compulsions. The common point is both are out of compulsions. That is of legal compulsion. This is of social compulsion. Got it? Summary table just for your quick revision. So we'll wind up the session for now. We'll meet or see you again at 10 o'clock.